we have a very exciting presentation workshop today. So I'm going to kick it off as people are joining. This will be recorded, so you'll be able to revisit if you've missed anything going in. So my name is Kat Trago. I would like to welcome everyone to the final session of our 4-part series, Leaping Forward, Evolving ESI Protocols, which has been brought to you by a collective group of Midwest chapters, including Chicago, Detroit, Denver, Ohio, and Wisconsin. Also, we want to quickly thank our sponsors, ACEDS, of course, and also eDiscovery Assistant. Today we have Kelly Twigger, who's leading our group. She's from that organization, as well as NextPoint and BDO. One of our sponsors, NextPoint, and has offered generously to send a hard copy to anybody who is attending this workshop and is interested in a hard copy of Tom O'Connor's book, eDiscovery for the Rest of Us. It's fantastic. It's very popular. And so if you are interested, I will send a follow-up email, but also I will be sending these out. So if you could email me your address, we're not going to collect that online. Instead, I'd rather you email me directly at ktrago@bdo.com, and I will get those books sent out to you. BDO is sponsoring the shipping, and NextPoint is sponsoring the book. So thank you very much for that. And then finally, I want to just take this opportunity to thank all of our previous session leaders. Angela Shapiro and Doug Matthews did a great job of kicking off our series and talking about, you know, the challenges of what you've agreed to, and then having, you know, being stuck with whatever you have agreed to in your ESI protocol, and the you know, cause for having to take a look at it and really put some thought into your ESI protocols. And then some of the present day pitfalls and things that need to start showing up in ESI protocols. We had Brett Burney, Craig Ball, Andy Keck, and Ann Costello talk about you know, some of the new technology and things that we need to start taking a look at. And of course, David Horgan always brings a great crowd, and we had some fantastic judges, Judge Barkenstale, Judge Goddard, and Judge Richland. That was a great conversation. And then today we are gonna, you know, bring everything into a conclusion with Kelly Twigger. And if I think everybody has had probably knows who Kelly is. She is a working attorney, and she is an entrepreneur, and most importantly, she is a huge advocate for education within the legal community. And she has, I would encourage anybody to attend the case of the week that she puts on through ACEDS every Tuesday. And I could go on and on about Kelly, but I'm not going to. She's also the founder of eDiscovery Assistant, which has has sponsored copies of any of the cases and rules and things like that that were addressed in any of our sessions. Those materials are on our website. So I would also encourage you to visit our website. It has materials, past recordings, bios for the speakers. All of that information is on that website. So it's a great resource that will be up for a long time to come. So with that, sorry, I'm trying to do this quickly, but I want to jump into our hypotheticals today. I want to also encourage everybody to put your cameras on, as we want this to be interactive. We want to see you. We want you can participate in whatever way you are comfortable. We will have somebody monitoring the chat. We will have somebody monitoring the Q&A session, as well as any of the reactions. So if you're not comfortable speaking up, please, you know, participate in any way that you're most comfortable. And with that, I would like to kick off our workshop with Kelly Twigger.
Wonderful. Thank you so much, Kat. I'm excited to be here. Apologies for my little bit of my rough voice, still dealing with voice issues, but I think we'll get through it. Kat, I'm going to move over and share. So let me, before we get started, I'm going to just explain to everybody how we're going to do things today. We just have 60 minutes. And for those of you that have drafted an ESI protocol, even if you're just the one sitting down at your desk to draft it, you know that it takes a lot longer than 60 minutes to do. So we're not going to be putting together language for a specific protocol today. What we're going to be doing is issue identification for protocol. And we're going to take a lot of the content or all the content that you've already experienced in the other pieces of this 4-part webinar series and be able to pull them together, leveraging a hypothetical. This is a very interactive workshop. This is not me talking to you. We are going to talk through the issues, and I need everybody to please turn your cameras on to participate, to think about the hypotheticals that we're going to see, and to, provide input. So you can raise your hand, as Kat mentioned, you can put something in the chat function, you can just speak up, and we'll be collecting all the information that we talk about in this document that I'm going to show you. So I'm going to switch over to the document that we've created. This is a Google Doc that will be shared with you after the event. And so you'll be able to keep track of all the information that was provided within it. Again, our goal is issue identification. And if you listen to the case of the week, or frankly, if you've heard me talk about or read anything I've written, you know that I'm a huge advocate that you have to start very, very early. And so the hypothetical that we've drafted here it iterates as we go through. There's 3 different iterations of it where we add new content. And so we're just going to talk through those things. So I'm going to go through the case hypothetical for you here quickly. You receive a notice via your alert system that a new complaint has been filed against XYZ Corporation, a client that you have represented previously for breach of contract. Although you've not handled a litigation matter for the company since before COVID in 2020, in the previous matters that your firm handled, you had a good understanding of the data sources that the client maintained. You do not know what changes have been made to their infrastructure since 2020. The complaint alleges that plaintiff ABC Corporation contracted with XYZ Corporation to design and implement a company-wide procurement and distribution system for all of ABC Corporation's factories and distribution facilities across the country. The project, bid on and run by XYZ, involved the design, development, configuration, and implementation of multiple SAP modules to create a unified procurement and distribution process following a merger that resulted in a newly formed ABC Corporation. So multiple companies came together, disparate systems, trying to pull together a whole new system for procurement and distribution. The complaint alleges that the contract was signed in 2020. I've got multiple people joining, which I'm getting screens of, so I'm going to add them. Was signed in 2020, that the parties worked together with additional third-party subcontractors for 2 years, and the implementation was abandoned in late 2022 following multiple issues with the rollout. ABC Corporation paid XYZ Corporation in excess of $50 million during the course of the work performed and seeks repayment for non-performance and the failure to hit milestones outlined in the contract. The original contract, which is attached to the complaint as an exhibit, included payment terms in excess of $100 million. Now, for those of you who are not familiar with it, SAP is an enterprise resource planning software that develops software modules that can be configured to the way a company does business. Multiple modules, and in this case, procurement and distribution, would be combined to allow for automation and management of the products needed to manufacture the products that ABC Corporation builds, sells, and distributes to its distributors. Those distributors then sell to retail locations sell to clients. So you've got components, that should say, set of products of products. You've got components of products, right, that have to come in through the procurement process, meaning they have to be bought from all over the world. They have to be implemented into the product. Inventories of those have to be managed at each of the manufacturing facilities. products have to be assembled, and then you've got distribution of those products to distributors to go into the retail chains. So very, very complex, especially when you're taking old systems and you have to adapt them to the new requirements for what it is that you want things to look like. So you're designing process and you're designing software to be able to implement that process. As you're contemplating how to reach out to the client, right? You got the complaint via your alert and you've read it. The client reaches out to you and tells you about the litigation and that you're one of 3 firms that they're asking to talk with about representing the company. You're not yet retained, but you have read the complaint. We're going to jump to the first questions. Based on the fact that you are on the call with a client right now and you've read the complaint, do you have questions or advice for the client during this call? And what are they? So I want you guys to start shouting out to me. You can shout out. We've got about 30 people on the call. So I think you can shout out things, put them in the Q&A, put them in the chat, put them in the reactions. And I'm counting on Kat and Abby and Pam to help me facilitate all of those. So what are the
Legal
questions
hold.
or advice that you have?
Need to discuss legal hold.
Right? What about legal hold?
You need to make sure that all the records, including the ones, I guess you had 2 companies merged, so you got to make sure the records for the other company, all of their records are held. You need to make sure you distribute to everybody who would have access to that. You've got a lot of distribution to do as far as like a legal hold letter.
Okay. So keep in mind that your client is potentially XYZ. ABC is the corporation that merged, right? So for your client, discuss legal hold. Totally agree with that. What's the question that you're going to discuss? What are you going to ask them? Have you done what?
Data map.
Well, let's start with what you already raised, which is have you sent out a legal hold?
Mm-hmm.
And then do you have a current data map is a good one. Don't worry about my typos. I'll fix them later. Okay. Anything else for advice to the client during the call? What determines the scope of your preservation? Hint, it's a timing issue.
You first hear or consider that a litigation would be
Right? When did the duty to preserve arise? Is that a right way to say it?
Exactly.
Right. When did the duty to preserve arise, right? What does the client know? What did the client know when? Is the complaint the first time they're hearing about it?
Right.
Given the facts that we know that the whole thing blew up, what do we think? Probably the first time or probably not?
Probably during negotiations at some point.
And then based on the fact that the duty to preserve arose, what else do we want to know from the client?
Did they
Who at the
preserve?
sorry, go ahead.
I was just going to say, did they preserve once they found out?
What steps have they taken to prove, identify, and preserve? Now, you haven't been retained yet by the client, but these are all really key questions out of the gate so that as the client goes through the process of choosing a firm, they don't lose further ground, right? So even though you haven't been retained, you've still got that obligation to really tell them what all the things you should be thinking about. Anything else that you see from this fact pattern? What about this?
Holly, there was a request that we put the fact pattern in the chat for reference.
Okay. I tell you what, whoever's monitoring the fact pattern, can you, or the chat, can you copy and paste it and put it in there? You guys all have access. Great, thanks. So with regard to the third-party subcontractors, has the client made any reach outs to or advised the third-party subcontractors of the litigation?
They're gonna need a litigation hold too, I would think.
Mhm. Okay. Anything else from this particular fact pattern that we see so far?
Could you scroll back up so I could get,
Sure.
thank you.
Mhm.
Thank you.
Mhm.
I got it.
You wanna know how many custodians you're looking at, cause that's gonna make a big difference in,
Yeah,
how
at
much
this
time it's
stage,
gonna take.
at this stage where you haven't been retained, I think we're going to hit that issue in the next version of, in the next piece of the hypothetical.
Okay.
But you're absolutely right. We absolutely
I
do
was
know.
just thinking as far as giving them any kind of, I guess if you're working hourly, you don't have to give them a bid, but they're always wanna know how much is it gonna cost.
Right? Scope. So scope, right? Scope of preservation, scope of litigation. Scope, this could be number of custodians, number of locations. Do they know data? Do they know data sources at this point? Have they thought about it? Okay.
Pre-2020, it looks like they knew the data source as well.
In 2020, you knew the data source as well. Yeah.
Right.
Right. But it's 3 years later and it was COVID. So what do we know that means?
A lot of people stopped working during COVID. A lot of people got COVID.
A lot of
Data's
people
in the
moved-
cloud.
Yeah, a lot of people moved to the cloud. A lot of people moved to Microsoft Teams, to using Slack, to using a lot of cloud-based applications that they weren't previously using, right? So when we talk about what are the e-discovery issues that arise out of that fact pattern, a lot of them are repetitive to what are the issues that the client has, right? That we want to know from the client. But is it safe to say here use of collaboration tools? Right? That you didn't previously have for this client. So you've got to rethink how you're going to address those collaboration tools. What else? Anything else? Third-party discovery for me is always a tremendous issue because it is like pulling teeth to get discovery from third parties. And there is case law now that is saying, if you don't do this early enough and you don't get the data during the discovery period before it closes, they'll preclude you from being able to go after those third parties for that information, or you're stuck with whatever you get, regardless of whether or not it's in a usable form.
Ellie, does cross-border come into play here, cross-border discovery, since it's sort of, across the country? I mean, we have to worry about that?
Well, cross-border is outside the United States. So, GDPR, those kinds of things. And this is purely a domestic action. I try to keep it a little bit simpler from that perspective. So I don't think we have cross-border issues here, but it's a good contemplation. Either one of these corporations could have been international, and you could be talking about data in other countries.
Because of their data potentially in the cloud, have them review their subscription, like when that stuff's being deleted, the retention on that.
So the retention policies, right?
and this could be really basic, but you know, names for conflicts. I mean, maybe we're assuming that, but we haven't we haven't retained them. So
That's right. They haven't retained us. Yes. So,
What about employee? Like an employee may have a cell phone that they've automatically got it to. You can make it so that you can delete information like on a regular basis. You want to make sure that no one else has an auto delete on the stuff that's going to their cell phone, whether it's emails after a certain period of time or whatever.
right. Okay, we're getting a little bit more into the facts. Let's move to our second, or the additional part of the hypothetical. Okay. So you and your team put together a proposal for the client and you're selected as counsel. Congratulations. You've joined what can only be described as a very complex situation. You have 30 days to answer the complaint. Yep, you got an extension. You attend an initial strategy meeting with the client that includes 2 attorneys from your team and a paralegal. Keep in mind it's a hypothetical and that's a dream for me. In-house counsel at XYZ Corporation. So your client, the procurement lead responsible for the contract, the actual development of the contract, and the IT director from XYZ responsible for the project and contract implementation. The IT director tells you that the communications were done with the entire development team for the project using Slack, including multiple subcontractor third parties. A separate Slack instance was established for the project that had more than 150 users, included more than 100 channels, permitted direct messages, and had more than 30 integrations with other applications, including Google Apps and Microsoft Teams, as well as project management, whiteboarding tools, and other tools for managing the project. The director tells you that the entire instance has been archived and maintained, but can be made active for counsel to review. XYZ maintains an enterprise license to Slack, and it is widely used for almost all of their projects. Correspondence with executives and others internally and at ABC Corporation was done via email. But when asked, the director concedes that he texted with several members of his team and they used a WhatsApp chat to talk about the project offline from Slack so that it was not part of the project documentation. The director also informs you that XYZ Corporation moved from Microsoft Exchange to Microsoft Email and Teams very quickly when COVID happened in spring 2020 to better allow for remote work. All right. Now we've got more information about the case and we're actually counsel on the case. Do we feel like we need to have a protocol for this case? I'm not looking at.
Absolutely.
Go ahead.
I would say yes, absolutely. And I would definitely put something in about calling back privilege. You have so many people. There's going to be issues with that depending on who is reviewing and how well they review.
I agree. The volumes would be extraordinary if you don't have something put in place to limit it.
Great, but if I could just jump in on 502D issues, you need the 502D clawback non-waiver order to be in a court-ordered document. Is the ESI protocol the right place for this? Are you going to have the ESI protocol just as an agreement among counsel, or are you going to ask the court to approve it?
Well, Judge, what are your thoughts on both of those?
You know, if the ESI protocol becomes so ordered, then you wind up where violation of it could be sanctioned, even if under 37E, you would not satisfy the requirements to be sanctioned or curative instructions. So I would say probably ESI protocol just as a party agreement, the protective order perhaps should be where the 502D language is, and that would then be court ordered. The other question, have we established, maybe I missed it, Kelly, is this case in federal court or state court? 502D.
Let's say it's in federal court. That's a good point, Judge. Let's say it's in federal court and we're governed by the Federal Rules of Civil Procedure. Excellent point. Excellent point. Or a state court that follows the Federal Rules of Civil Procedure, but a federal court is easier. Okay, what other, do we have any dissenters on whether or not we would have an ESI protocol here? Abby, Pam, Kat, we getting any feedback?
No questions in the Q&A.
Okay.
The only comment I would make is, what's the scope of the ESI protocol? You probably need an ESI protocol merely for form of production. When you start negotiating an ESI protocol that carries over into everything, custodians, non-custodial sources, search terms, TAR or not, you're then negotiating for months and months and possibly locking yourself in on something you don't need to have locked in early. So simple ESI protocol, yes. More complicated one, I don't think we know enough yet.
Okay, agree with all of that. Anybody have a different take? Okay, I would agree with all of that. And when I was planning this out, because we just had an hour, I originally had thought we had 90 minutes. We just have an hour. If you have, say, a simple, let's say you have a simple workplace harassment claim, and I'm not to allege that the facts that those are simple and not important, but say you've got it's simpler from a litigation perspective. You've got a couple of data sources, you've got 2 or 3 custodians that are really involved. Those are things that I think you can handle either in a really simple way. You may still want a form of production written out because of the complexity of the data sources that may be at issue. Emojis are often at issue. Text messages are often at issue. Slack messages, those kinds of things. And form is really important to you being able to leverage the data effectively. And so a simple protocol may be really important in those situations. I think there are also situations, and we have a number of them on our firm side, where it's really not necessary to do a protocol because you've got no sophistication about e-discovery on either side. And there's very little data that needs to be exchanged, and no one's really questioning the authenticity of that data. It's just, give me your emails, give me your text messages, and let's move forward. In those situations, I don't think you need something. But it is always a moment-to-moment question that you need to be engaged with. And as we're seeing here, the earlier you think about these issues, the easier it's going to be to be able to anticipate them and adapt to them.
Can I ask one follow-up? Are there instances where you do recommend a complex protocol with very detailed descriptions of everything you could have thought of preliminarily, or would you generally recommend including language on, meeting and conferring on those issues later on?
The biggest factor for me in that analysis, and I'd love for anyone else to weigh in, is who I'm working with on the other side.
Right.
There are a number of amazing lawyers across the country at firms who will sit down with you and work together to come up to an effective protocol that both drills into the things that everyone can be sure of, but also will include language like we're going to talk about that is what I call the get out of jail free card.
Okay.
Right. So so you can dial back when you agree to produce hyperlink files and you find out you can't do it. Right. You can get excused for good cause. That's the NRA StubHub most recent ruling. And so that to me is a huge player in how complex your protocol needs to be. The other thing is, I think, in asymmetrical litigation, when you're the party who doesn't have the most data, you want to try and protect your clients. So you're making sure that you're getting what you need.
Right.
But I also think that those situations are the ones that are the most fraught and the ones that tend to carry on for months and months and months. There's at the end of this a sample protocol that I've identified for everybody that's in this document. You'll have a link to it that you can leverage if you want to. That is from the In-Ray Uber Technologies litigation that is just very, very, very thoughtful. Doesn't have everything in it that you could put in it, but the whole point and one of our themes for this entire series is your protocol needs to fit your case. So there's certain things, if you're going to do a protocol and you're going to have a judge sign off on, you got to include. You got to say we're going to cooperate. Some courts require you to have a liaison, and some courts, like the Northern District of California, have a sample protocol for you to leverage, and they want to see a lot of those items in the protocol. So it's about who's on the other side, the complexity of your case. A big part of it is the value of your case as well. And, so then all those pieces kind of flow together. Anybody have anything else to add to that? Any other factors that they consider in the complexity of the protocol? Okay. I've negotiated 2-page protocols and I've negotiated 45-page protocols. So it very much depends on the complexity of your case, your level of comfort with opposing counsel, and the judge that you have as well. There are judges who are really good at these things, and judges who put everything on the parties to be able to resolve. So all of those things sort of factor in. All right. What are the other, just going back to our question here, what are the other issues that this fact pattern raises? So
data loss.
Okay. What about sources? What about data loss?
With the migration of the data and the fast pace at which people or corporations migrated that data during the COVID, did everything transfer and migrate successfully with regard to the exchange, email and Teams? And then what about the assets as far as the mobile phones?
Right. So mobile devices.
And if people left the company, what happened to those devices? Was that data successfully retained or was it deleted?
And were those mobile phones personal or company?
And we've got some of the people using WhatsApp, which might have no retention other than on the phones themselves.
Okay. Data retention, and then I'm going to hashtag this here, mark it with collection strategy, right? Because WhatsApp is an application that can be a mobile device application. So for example, the WhatsApp messages that I have personally, because my in-laws live in the United Kingdom, so we communicate via WhatsApp. I have them on my device, and I have them on my laptop. So, if the custodian uses Apple and has the ability to do those things, or if the application allows itself to be a desktop application on a Windows application, those are really complex things that you have to get into with each individual custodian. And, okay, so WhatsApp, what else? What were the other large data sources in our?
I would be concerned about the collection of SAP since it isn't easily collectible.
What is it that you're going to collect from SAP?
Yep.
I'm asking you, what is it that you're going to collect from SAP?
Depends what kind of documents they have in there and what you're looking for.
So SAP is software, right?
Right.
And these are 100+ developers developing software.
Yep.
So what is it you're actually going to want from SAP if that data is relevant?
Is it structured data at
It's
that
source
point?
code.
Or source code, excuse me, that makes more sense.
So you're going to have you're going to have all the design documentation around the system, right? Which can be in a number of different forms, but then you're going to have the actual source code that was developed. So if you have, let's say you had 25 different problems and each one has to be analyzed, you'll have to look at both the design of what was to be analyzed, the correspondence around the changes and implementation of that design, and then the actual source code that was developed, right? So typically we'll have a separate protocol for source code. Those are sometimes put in ESI protocols, but oftentimes it will say where source code is implicated and the parties agree that it's relevant, they will meet and confer about a process for providing access to source code. So that's a whole separate thing. We actually have an issue tag for that in eDiscovery Assistant. You can find the cases where source code has been discussed, and there are specific protocols for source code. So SAP collection is a good one. What's the biggest one? What's the biggest one that the developers use to communicate?
Slack.
Right. We've got Slack. Raise your hand on the call at how many people have used Slack or know and understand how Slack works. Somebody tell me how many people are raising their hand. I just see one so far. Just one person that uses Slack or knows and understands how Slack works. Okay, so Slack is, I was going to show you my Slack, but then that's probably not the best idea. So Slack works in a couple of different ways. Within Slack, you create an instance, right? You could call instance like a project, but an instance can be for anything. We have separate instances for the different companies that we have. You know, I'm in a legal tech instance. There's a women's instance that I'm in. I have probably 10 or 12 different instances of Slack on my desktop Slack. Within each instance, you can create channels, which you can then invite people to, and they're typically subject-based. So most organizations have a general channel or a chit chat channel where people just communicate day to day, or they're just, you know, water cooler sort of discussion. And then you might have individual channels for each element of a project. You might have one for high level information, contract specifications, those kinds of things. So you really have to be able to examine that Slack instance to understand how that information is organized. The second way you can communicate in Slack is via direct message. And you can create direct messages with one person, or you can create them with multiple people. And only those users then have access to those direct messages. So when you collect Slack, you have to identify what channels are going to be relevant, what custodians are going to be relevant. You have to collect all that individual information, and you have to collect it in a way that maintains the organizational integrity of that information. So Slack is complex in the same way that Teams is. It's very equivalent to Teams. Teams is, in my view, a little bit of a Slack knockoff. I've been using Slack for about 10 years though, so I'm maybe a little biased. So you've got collection issues. You've also got 150 custodians who are using Slack, right? So what else associated with Slack? If we go back up to our thing here, you've got 150 users, 100 channels, direct messages. What else do we see here? Integrations.
And what about links to external documents,
Right?
websites or whatever? Modern attachments.
I like to call them hyperlinked files. Hyperlinked files. What else can you do in Slack? What do you guys do in Teams? Does anybody use emojis in Teams? Yeah.
Yep.
Okay, we're going to get to that a little bit more as we move through. So the only way really to effectively be able to make a reasonable determination of what your scope of preservation, collection, production is with things like Slack, and frankly, all of these data sources, is to look at them. So if there's one takeaway that I would give you, and I'm sure you've gotten it from the other 3 sessions, don't just sit down and draft a protocol. Don't take a template and just implement it. Even if you've had Slack in previous cases, you need to understand how Slack operates in the particular case you're in so that you know what the issues are when you're drafting the language for your protocol. Remember, it's a protocol for the specific case, the specific data sources, and the specific clients that you have. Okay, what else from this particular one? We've also got Google Apps and Microsoft Teams and all of the integrations. Whether the integrations, with those integrations, does the data actually live in Slack, or is it a link out to those integrations? And do we need to go and collect those integrations? And if we do, is that physically possible with technology? And can you in any way relate the information that you've collected as part of a Slack message to, say, a whiteboard? Can you integrate that and produce it with metadata to show a relationship, right? Those are all things that you need to test out and understand before you can agree to language in a protocol. It's very similar to the hyperlink files issue, the integrations and the ability to collect that data. The only way you're going to know is to test it. And keep in mind that what didn't work when the data was originally created back in 2020 may work with existing technology now. And Judge, I want you to jump in here. My view is your obligations to produce information are based on the technology that exists at the time you have an obligation to produce it. Judge, what do you think of that?
Yeah, but yes, but, or it depends, as we always say. There may be times where, this isn't in our hypothetical, you were using a free version of Slack or something else, and there may or may not, depending on cost and proportionality, be an obligation to upgrade so you can get more of that data preserved.
Totally agree. Yeah, 100% agree. You've got that issue with Teams, right? You've got different capabilities in an E3 license than you do in an E5 license. And the same is true with Slack. And that's why in this particular hypothetical, I said that XYZ has an enterprise license. An enterprise license will allow you to export all of that information. They've built in some e-discovery functionality now that didn't exist in 2020. So it is about that. And I 100% agree with what the judge said. And that is that, you've got proportionality considerations, cost considerations as to whether you're required to upgrade to do things. Okay. We also talked about, we talked a little bit about WhatsApp in the first question, but we've got WhatsApp here. And we also, did we talk about mobile devices? Is mobile devices in this part? Nope, not yet. So what about WhatsApp? Same as what we talked about in the previous question, right? That we really have to be able to understand where it exists and that it was collected and whether or not it was retained. So, so for WhatsApp, we've got potential spoliation. Okay. What about, oh my gosh, we're going so fast through this and we haven't gotten to part 3 yet. What about any thoughts? We'll do some of these questions quicker. We talked about these already. What are some of the approaches that you might use given the large number of custodians that you have?
You might ask if there's any sub-team mailbox so that the 5 developers writing code for, 1, 2, 3 would send everything to a common mailbox so you don't have to go to their individual mailboxes necessarily.
What about something along the lines of, I'm thinking more in terms of the number of custodians that you have. What about identifying and working with the other side to identify an early subset of sampling of custodians that then allow you to branch from there? Like you agree initially to, let's say 10 in this particular case, right? And then, I mean, we find even in the largest of largest cases that getting much beyond 25, 30 custodians, the value of your data really diminishes because they've just copied the same people over and over again. So
The duplication.
I'm sorry?
I would think there was going to be a lot of duplication if they're all collaborating on the same thing.
Right, right. But typically in those kinds of projects, and I just know this because I've done a lot of development, you know, you have people that work on different aspects, right? So you may have one person who's responsible for one feature and one person who's responsible for another. So I think in this particular instance, to me, I want to now understand where the 10 or 15 issues were that went awry with the development that caused the whole project to be abandoned. And I'd want to dig into those issues and really focus on the data. I don't want to produce 2 years of Slack data with 100 channels and 150 custodians direct messages. That's so much data. I don't even know how you'd get through it. So you want to be able to really focus on those problems. I feel like in this kind of case, if you have cooperation with the other side, transparency on those issues is going to be important. I also think continuous communication with the client about how things were handled and what happened as problems come up is critical. A lot of times as litigators, we feel like we've talked to the client, we go back to our office, we sit down to do stuff, and then we go, oh, I don't know the answers to these 10 questions. And I don't feel like I can call my client again. Call the client again.
Did you also do custodial interviews to try to understand?
And specifically at the custodial interviews, what do you need to focus on?
Well, just looking at the next one, I would probably say, were there certain terms or acronyms that you were using when you were talking about these projects? Or your, you know, your piece of it or whatever.
Yep, you're getting even to my next question, right? So my follow-up question to that is, do you use the same search terms in email that you'd use for text messages, Slack, or WhatsApp? So we'd want to have search terms for each individual platform, right? Which complicates things. And then you've got to test those, right?
I'm just going to chime in and add one thing, you know, in terms of, you're talking about focusing for like the final 10 or 20, but also making sure all 150 people know of their obligation so that if you miss somebody at the beginning, everyone will be able to testify, yeah, I didn't delete anything. I didn't, you know, I preserve, you know, I didn't do anything to intentionally destroy or hide things.
Could not agree more. If you just watched my case of the week this week or read it, just came out. That's 100% what I said. Great point, Megan. Thank you.
Okay, thanks.
All right. Search terms we covered a little bit. I'm moving us quickly. We talked a little bit about mobile device data. What are the types of data we have from the mobile devices so far? We've got WhatsApp. We talked about. What else?
Texts.
Text. So do we have to collect the entire phone, or could we do a targeted collection of just certain applications from a certain date range?
Targeted.
We didn't really touch on the preservation date range, which is always going to be the thing that guides you in the scope of everything that you're doing. We don't really have it yet in this hypothetical, so it's harder to focus on. We talked a lot about the specific data sources already. What about third-party? What about third-party subcontractors? What do we need to do for those third-party people? How about understand the relationship to your clients?
Yeah, you need to understand the terms of the data, you know, ownership in their contract, in their MSA and stuff like that.
Mm-hmm. Right?
Yeah, big picture, since we're looking at the rules, you know, what's under their possession, custody, or control.
Right.
And then part of the concern I have, right, is we know that the Slack was shared across parties. So it seems like at least that data would be, in the control of the merged entity.
Yep. So it really depends. So in this situation, does the merged entity, so in our fact scenario, XYZ, which was managing the project, owns the Slack instance.
Right.
And they had that. So once the project was turned off, everyone's access to the Slack data was turned off. Did anyone take any steps? What are the audit logs or anything? Did anyone take any steps to destroy any data before that Slack was looked at? Those are issues that I tend to get into when I find that the information people say should be there isn't there. Then we go back and look at audit logs. And those should still exist as long as the implication is, or as long as the instance has been archived. Okay, let's jump to the hypothetical part 3. We are at 11:52, so I'm going to try and move quick through this so we can hit our themes. If you guys can stay on for a few extra minutes with us, great. Hypothetical part 3. You conduct custodian interviews and you review the Slack instance. Both tell you that the parties shared documents via links in Slack, Teams, and email. ABC Corporation uses Google Apps, and that the parties made up their own emojis, which they uploaded to Slack and used to share responses to what was happening in the project. One custodian you speak to tells you that there were dumpster fire emojis and various other emojis involving flames and face palming that were shared in the last year of the project as it became apparent that timelines were not being met and the project was not going well. What other additional issues do these discussions bring to light? Smiles to your faces.
So part of it, I know we sort of discussed earlier, but there's always a question of what time frame should trigger your lit holds. And here, given that, you have the dumpster fire emoji and other emojis like that show that, timelines were not being met, it seems to potentially trigger that. So you'd have to consider that. And then, of course, it may be helpful to determine the meanings of all of these. I think we can assume what dumpster fire means and what some of these mean, but if they created their own emojis, maybe a smiley emoji means something sarcastic other than just whatever you would assume.
Right. Like I can tell you without a doubt, half the time people send me emojis and I have no idea what they're saying. But my teenagers all do. Mom, come on, that means X. I'm like, not only did I not see that, I don't even want to figure it out. So yes, the other issue you have with emojis is when you collect them, because emojis are Unicode, right? They're elements of Unicode. They're not images. When you collect them, does the tool that you use to collect them give you the same emoji that was actually in the Slack instance or in the application where you got those emojis from? And how can you do a QC to be able to test that? And what do you gonna have to show if there's a question about that? So lots of issues in emojis. I was part of the emoji series that ACEDS did last year. If you haven't seen that, I highly recommend that you watch it. Most of the case law all happened 2023. We really haven't seen any emoji case law in 2024 at all. So most of those issues are still pretty consistent. But that webinar series, particularly the one that Matt Mahan did, talking about all the issues inherent in emojis, really good. I recommend you go back and watch that. It's all free. We'll put the link to that as well in the materials that we send to you after. Now, should you put all of these issues in the ESI protocol? What of these issues that we've identified so far should go in the ESI protocol? We've got a lot of form of production. Are we going to put anything about form of production for emojis and QCing those emojis?
I would think we have to if.
I've been asking Sawyer when he's gonna start leaving and he hasn't told me yet. So I definitely, oh shoot.
I would have to, especially if you've got one custodian telling you that these definitely mean something. So
Right.
I think, yeah.
And especially if you're talking about a dumpster fire triggering the duty to preserve. And the question of who the dumpster fire emoji was shared with. If it's just shared with 2 developers who are subcontractors and have no decision-making authority, that is different than perhaps it being shared with the supervisor of, hey, are you seeing what's happening in this Slack channel where everybody's has blowing up dumpster fires? So I think all of these are considerations about how are you going to handle it. So we've got form of production there. We've got Slack messages. We've got hyperlinked files. This is a separate, not form production. So you've got some complex issues here. What about search terms? We didn't really get to discussing all of the complexity that goes into how are you going to do search terms. So I will throw this out there, and I look to anyone to provide commentary and Judge Peck weigh in. My profound belief is that the party who is producing the information should provide search terms that are responsive to requests for production or to specific topics. Generically, having the receiving party throwing out search terms to you and iterating from there is a recipe for disaster, and that's what takes months. Thoughts? Anyone else disagree?
I think the producing party knows their data the best. So yes,
That's right. That's right. That's
and
my
I think we also need to make sure we've got the date range in the
Just one caveat on the search terms. If it's internal communications, then for sure, the party whose data it is should come up with the search terms. If it's the 2 parties to the case talking to each other, getting suggestions from the other side might be helpful.
Mm-hmm. Yeah, I absolutely ask my clients what terminology they use to communicate with the other side, especially since if I don't see those terms in what's proposed to me, it's a bit of a red flag.
I think also narrowing down the search terms, which is why I always recommend our clients to do a search term report first. So as you're trying to figure out your search terms, maybe a more complex search term needs to come out if your first search term is coming out with 1 million results. So that's important as well.
And when you talk about a search term report, you're talking about a hit report?
Yeah.
Mm-hmm. I go back and forth on the value of exchanging hit reports with the other side, but I 100% agree with you that they are useful to evaluate internally. What else? We're at the top of the hour, so I want to be cognizant of everybody's time. We've also got Google Apps, and we've got Teams. So we've got specific sources of data. A huge piece for me that always needs to go in a protocol, even if you do a very simple one, is the metadata for each application, because they're all different. The metadata that you use from Teams, the metadata that you use from Slack, social media metadata, text message metadata, WhatsApp metadata, they're all different. So if you aren't familiar with the metadata that's available for those applications, it's really easy to Google it and see what the list is of fields that are available. And then think about what are the ones you actually need to be able to use, leverage, authenticate, search, filter the data, and then include those. So the schedule of metadata that comes usually as Exhibit A to a protocol, I find to be one of the most important elements of being able to leverage ESI, because you want to be able to search and filter it and find what you're looking for. What else anybody has in terms of what else we should address in our ESI protocol for this particular case? Do we want to put in cooperation? What about our get out of jail free card? I call that the good cause. So, and that's what you saw in the NRA StubHub case. If you guys read that decision where the judge came back and said, well, you guys said you could alter the protocol for a good cause, and StubHub has come back and said they're not physically able to provide hyperlinked files, even though they agreed to do that. And so therefore, I'm going to amend the ESI protocol, and everyone go have a nice day. That's really key information, I think, to be included in every protocol, because you never know what's going to come out. And that always balances the point that Judge Peck raised when we started, which is you've got to think very carefully about, I can agree to this with the other side. Do I want to have the court enter it and therefore be subject to potential sanctions for violation of it under Rule 37B? Or do I not want to include it? I mean, there are often very strategic reasons not to agree to things in an ESI protocol. Sometimes people say the parties will just meet and confer about custodians, data sources, all of these pieces. They won't lock themselves into the data sources that they agree to in a protocol. I have also had one other situation I think is worth mentioning, and that is, and I think this happens to all of us, there are always data sources that get identified 3 months before discovery ends, right? Somebody is looking, they realize that their case isn't going quite as great as they wanted it to, and so they start looking at the data and they go, oh, well, this database is mentioned in 5 emails. Where's that database? Why didn't you guys give us data from that database? And you go, that you've never mentioned that database before ever. It has nothing that's relevant or responsive to your request for production. What's the issue? But they make a huge stink about that database. So there is merit to having a list of the sources of ESI that you've agreed on, and to say that if a parties identify a new source, that it will be brought, within a reasonable amount of time. And then that can become an issue and something has to go before the court. So, all right, we're a few minutes past the hour. I wanted to finish up with a couple of things, themes about ESI protocols and drafting. Start as early as possible. I mean, in our analysis here, we started before you even got retained. And so, help the client be thinking through these issues. If you're ultimately going to take on these cases, it's not very much fun to walk into a case where there's already huge sanctions issues. So you want to try to help the client identify that those issues exist. Same with the initial strategy meeting. Where is the Slack instance? Having the guy tell you that it's archived. I would want to go and look at that Slack instance almost immediately. I would want to leave that meeting with a time set up with that IT director for me to physically look at that Slack instance and verify that it still exists. Because if it doesn't, that's a huge problem, right? So start as early as possible to identify those issues around data and what strategic decisions you want to make about whether or not to put them in a protocol and how detailed you want them to be. Again, those are all going to depend on the level of knowledge you've got on the other side, the level of complexity of the litigation, value of the litigation. All those things come into play. The other things that come into play are whether or not your client is a publicly held corporation, and whether they want their ESI as a protocol as a published document from the docket. So if the court signs off on it, it's a decision that is then publicly available information. And do you want that? Do you want the other side to, in other cases, to be able to see that? All of those are strategic decisions that you need to take into account. Next theme, if your client doesn't already have one, use the information that you learn in this litigation to help them develop a mini data map. It can be as simple as a spreadsheet that just says source of ESI, location of that ESI, the retention as you currently know it, and a liaison within the organization for you to talk to find out more information about it. It doesn't have to be very detailed. Third, probably the most important one, always make a protocol fit your case. Starting with a template is helpful, but the content should always be reevaluated. We identified a number of strategic decisions here in this case that you might alter with one little fact. The company isn't public today, but they're going public in 6 months. And what information do they want out there? So always remember that litigation has a tremendous impact on a business beyond the cost of the litigation. The visibility, the goodwill, everything associated with that has an impact on the business, and you've got to think about those things. And finally, be sure to include what I call your get out of jail free pass. You want to include language that allows you to modify that protocol for good cause. One of the sample protocols that I really like that is out right now is the In re Ubertech sexual assault litigation protocol. The link to it is highlighted there. And here's what I like about it. It's really transparent. It's easy to understand. It doesn't have a lot of jargon in it that the judges can't understand. You know, a lot of judges will say, I'm going to sign this, but I have no idea what you guys are talking about. Right. And there's things that as the technology develops, that's not the judge's job to understand that. So make it as simple as you can make it. It also establishes an open dialogue with the parties between what exists. And because of that, it reduces a lot of potential for discovery motions because of the number of things that are discussed in it. And it builds off the case law that's already decided on by the courts. In fact, this protocol specifically addresses the language that's referenced in some of the hyperlinked files cases about, you know, if existing technology allows us to do it, we will do it. If it doesn't, we can't do it. And then that good cause language is included there. Other things that it might have included, the 502D language, which Judge Peck raised, he might or might not include in a protocol, depending on whether you're going to have the court sign off on it, and dealing with search terms for different applications. In this protocol, as in most protocols that I see, the search term discussion is very generic and it's not by application. There wasn't anything about emojis in that particular protocol, but I think we showed pretty clearly in our hypothetical that emojis would be a pretty big issue. And we do have case law in the United States and also from Canada that talks about judges allowing things to move forward and allowing the implications of emojis to be language because people are communicating via emojis. All right, those are the things that I wanted to cover for today. I know we're a few minutes over. I apologize.
My neighbor showed me the app.
I'm sorry, say that again. Somebody had something. So just a reiteration, the materials are available on the website. You'll get an email, I think, following up with a lot of the links to materials as well. We will be sharing this document. So you've got the information that we put together following this hypothetical. This is my hypothetical. I would appreciate it if you didn't knock it off and use it for your own benefit. I think that kind of wraps us up in terms of final comments. Kat, did you have anything you wanted to add to close us out?
Only to say thank you so much, Kelly. I also appreciate how you tied in our last series, the emoji series, into, so well done. And thank you all for attending. Just a reminder, if you're interested in a hard copy of the book that is being sponsored from Next Point, E-Discovery for the Rest of Us by Tom O'Connor, just shoot me an email at ktrago, I'm still getting used to that email, at bdo.com. It's in the chat. Also, I put the link to our website for the series. It has materials and recordings. This will be uploaded shortly after the presentation. So with that, Kelly, thank you very much. I think this was a really interesting, and I really appreciate all of the interaction that we got from everybody. I think it was a really great collaboration, and I hope that you all agree. So
yeah, just
thank you so
wondering, I was
much.
just looking at the chat real quick. Somebody mentioned that the link doesn't work in what was pasted in the chat. You'll get the document and the link will work from there to the Uber protocol. Okay, great. Thanks everybody for joining us today. I hope you have a fantastic rest of the week and you're enjoying your summer. All right.
Thank you so much.
Thank you.
This was great. Thank you.
Bye, everybody.
Thank you.